Hi, I'm Judge Moore. Pleasure to be here. About a week ago, I was asked by Judge Wells, Natalie Keller, Carol Adams, Mr. Clark, Ms. Clark, Hilda Zamora to present today on minors counsel. Very excited to do that. My presentation is going to kind of take us towards an analysis of evidence in the area of family law. In the beginning, I'm going to go over the statutes and rules of court on minors counsel. I'm going to do it quickly because I know that you're probably getting it from other sources, but it's helpful to me in presenting here to start with those principles and then move towards a discussion of evidence. If you recall my presentation last year on parental alienation, I didn't budget my time well. The recommendation here is 45 minutes. I'm probably going to go closer to an hour. I might go fast and furiously in some parts, but I'm going to do my best, and let's get started. I'll now start sharing the PowerPoint. Okay, minors counsel, starting with Family Code Section 3150. We are told in Section 3150 that if the court determines that it would be in the best interest of the minor child, the court may appoint private counsel to represent the interest of the child in a custody or visitation proceeding, provided court and counsel comply with the rule of court. One moment. All right, so that's the starting point, Section 3150. Again, I'm going to go a little quickly here because you've probably gone through the statutes and the codes in other presentations, but it's helpful to do it as a starting point here. 3151, the child's counsel appointed under this chapter is charged with the representation of what? What we see so often, the child's best interests. Now, minors counsel's duties, unless under the circumstances it's inappropriate to exercise those duties, are at least three things. One, interviewing the child. Two, reviewing the court files and all accessible relevant records available to both parties. And three, making any further investigations as counsel considers necessary. All right, those are your three minimum duties under Section 3151. Let's go to the rules of court. In Rule 5.240, this is when a judge or a commissioner should consider appointing minors counsel. When should that happen? One, when the issues of child custody and visitation are highly contested or protracted. I'd say that's the majority of our family law cases, at least those involving children. Two, when the child is subjected to stress as a result of the dispute between the parents, and the stress might be alleviated by the intervention of minors counsel. Three, counsel representing the child will be likely to provide the court with relevant information not otherwise readily available. I think minors counsel can be very well suited to this. It's not that all parents don't have their child's or children's best interest in mind, but a lot of parents have their foremost interest in mind ahead of the child, and they may have a motive to withhold necessary information. They may have a motive not to give us truthful information. So I think minors counsel can be very helpful here. Another instance in which the court should consider appointing a minors counsel is when the dispute involves allegations of physical, emotional, or sexual abuse or neglect of the child. All right, when else should the court consider appointing a minors counsel? When it appears that one or both parents are incapable of providing a stable, safe, and secure environment. I like that alliteration, stable, safe, and secure environment. If the parents are incapable of providing it, minors counsel is probably a very good idea. 6, counsel is available for appointment who is knowledgeable about the issues being raised. Perhaps the minors counsel served as counsel for mom and dad in a different case, and the child we're talking about now is a niece or nephew of the parents in the other case. Let me put it another way. Minors counsel is already familiar with the family or the extended family from another case. They have a little bit of background in the issues in this family. That might be a circumstance where this particular attorney, hypothetically, would be a good person to appoint as minors counsel for a niece or a nephew or a cousin. Of course, there could be a conflict depending on the facts and circumstances of the case, but not uncommon in Blythe, for instance, to have extended families that have multiple family law cases. This is kind of what comes to mind for me when we think of knowledgeable attorneys who could serve as minors counsel. 7, the best interest, there we see that again, the best interest of the child appears to require independent representation. 8, if there are 2 or more children, any child will require separate counsel to avoid a conflict of interest. I do not read this to mean that anytime there are multiple children, there must be multiple minors counsel. I don't read that at all. We're lucky to have minors counsel here to begin with. But of course, there could be circumstances in which multiple children would need multiple minors counsel due to competing or conflicting interests. All right. Rule 5.242 subdivision I, again, rights of minors counsel. I'm going a little bit quick here because you've probably already been through this in other presentations, so please bear with me. What are the rights of minors counsel? There's many of them. 1, you have the right to reasonable access to the child. 2, you have the right to seek affirmative relief on behalf of the child. You can seek your own RFO as minors counsel. 3, you're entitled to notice of any proceeding in all phases of that proceeding, including a request for exam affecting the child. To me, this is kind of a Marcy's law of rights for minors counsel. You have the right to take any action available to a party. So whatever mom and dad could ask the court to do, minors counsel could do as well on behalf of the client. The right to be heard in the proceeding, which may include presenting motions and orders to show cause. Again, I see this as very similar to 2 and 3, and also to a large degree 4. Basically, minors counsel is not a second-class citizen in the case. Minors counsel is basically entitled to do all the same things that counsel for mom and dad can do. All right, continuing, 5.242 subdivision I, rights of minors counsel, also include access to the child's medical, dental, mental health, and other health care records. Kind of like having legal custody, you have those same rights. 7, the right to inspect juvenile case files if they exist, subject, of course, to WNI 827, the gatekeeping statute to inspecting delinquency and dependency records. 8, the right to interview school personnel, caretakers, or healthcare providers. However, and I set this apart, although it's still under subdivision I, paragraph 8, the release of this information, if that happens, if the release of this information does not constitute a waiver of confidentiality, if any, right? I'm looking at the healthcare providers, for instance. There might be doctor-patient, there might be psychotherapist-patient privileges. But you have the right to interview those folks. You have the right to access those records as minors counsel. Okay, keeps going. Many rights. You have the right to interview the mediators. You have the right to receive reasonable advance notice of and the right to refuse physical or psych examinations of your client, subject, of course, to a court order. You have the right to assert or waive any privilege on behalf of your client, the child. You have the right to seek independent psych or physical exams or evaluations of the child for purposes of the court proceeding. The right to receive a child custody evaluation report, if any, in the case. The right not to be called as a witness in the proceeding. Minors counsel may obtain very important hearsay statements from the child or others. Cannot call minors counsel as a witness. Minors counsel may request the court to authorize the release of relevant reports or files from CPS is one example. And very importantly, minors counsel has the right to be compensated. The right to be compensated financially. Now, we of course love it when minors counsel do this pro bono, but under the rules of court, you at least have the right to compensation, and that's why I have this paragraph in green. Now, rights of minors counsel, let's go to responsibilities of minors counsel. They're 5.242 subdivision J. You're charged with what? Of course, the best interest. When in doubt, best interest standard applies in family law, it seems everywhere. The role of the child's counsel is to gather evidence that bears on the best interest of the child and present that admissible evidence to the court in any manner appropriate for minors counsel. Again, the role of the child's counsel is to gather evidence that bears on the best interest of the child and present that admissible evidence to the court in any manner appropriate for minors counsel. And if the child so desires, the child's counsel must present the child's wishes to the court. Repeat, if the child so desires, the child's counsel must present the child's wishes to the court. So we're going to move now to more of a discussion about admissible evidence. And this may not just apply for minors counsel, but kind of across the board in family law cases. All right, before I do, I'm going quickly, I want to emphasize that I really feel that minors counsel can be extremely important in a case. We can't have it in every case. I wish we could have it in more cases, But I have found in my cases that when we do have minors counsel, it's been extremely helpful. You know, in dependency, I have presided over a few dependency cases, not many, but the reports from the social workers are extremely, extremely thorough. Sometimes I would say almost too thorough. I've never or rarely found when I'm sitting in dependency court that I don't have enough information, that I don't know what I need to know. Exceptions, of course. Family law is very different. I don't have a social worker that's interviewing the parents or the children or the teachers or the doctors. I don't have that, or the police officers. Family law is difficult for a lot of reasons, not the least of which is often I find that I don't have the information that I need, or that I feel that I need to make the right decision. I can question the parents at length, I can continue it, but that's what's sometimes frustrating. I do the very best I can, but I have to wonder sometimes, would this be different if there were lawyers, right? Would this be different if I had a social worker doing the kind of investigations that can take place in dependency? So in those cases where minors counsel are appointed, I personally feel better. I feel better that I have the kind of record that I need to make sure that I can make the decision that's in the best interest of the child or children. All right. Now, moving to the more evidentiary portion of this presentation. Some of this I got through last year. I can't believe that it's been a year almost since we had an in-person family law presentation. My, how time flies. But can't hurt to just briefly go through Elkins. We know the evidence code applies in family law. I'm not trying to be flippant, but you have the right to object on hearsay grounds in family law. You have the right to request that it not be a mere trial by declaration, as often happens in traffic cases. So absent that stipulation, no trial by written declaration in family law. I'm not saying that trials can't happen based on declarations. In RFOs, for instance, we have all sorts of instances where decisions are made based on sworn declarations. But certainly at trial, Family Code 217, if you insist upon cross-examination, you insist upon application of the evidence code, you get it. All right, I don't need to bore you. I don't know if it's boring, but I don't need to spend a whole lot of time explaining why the Elkins court reached the decision that it did, which of course ultimately led to the Elkins task force. But I like the last sentence. The same judicial resources and safeguards should be committed to a family law trial as are committed to other civil proceedings. I don't think any of us would disagree with that. All right. We know that the evidence code applies in family law because Section 300 tells us, except as otherwise provided by statute, this code applies in every action before the Supreme Court, Court of Appeal, or Superior Court. So because the evidence code applies, that means the hearsay rule applies. Ms. Adams, in asking me to put this together, expressed that she wanted or felt that some additional training on hearsay would be a good idea. I don't want to spend too much time on the definition of hearsay because we all know what it is. We all know it when we see it. We all know it when we hear it, but we can't skip steps with it, right? And so what I'm going to say for now is this. We know that hearsay is any statement made outside of court that is offered for the truth of the matter asserted. What I often see in criminal cases and what I sometimes see in family law cases or civil cases is a witness that's on the stand and the witness makes a sworn statement under oath in court and then also takes the opportunity to repeat something that the witness said outside of court, not under oath. And the argument is, hey, that's not hearsay because I'm here affirming what I said outside of court. And the answer is no. If it was hearsay when made, it's always going to be hearsay. There could be an exception. There could be an exception, all right? But just because the declarant takes the stand, whether it's mom, whether it's dad, whether it's a third-party witness, all right, their mere availability on the witness stand does not make their prior statements admissible per se. I repeat, their mere availability for cross-examination on the witness stand right now does not make their prior statements, whether sworn or unsworn, admissible per se, right? Unless it was made in this court right now under oath today, it is hearsay. Again, there may be instances where the attorneys agree that prior declarations can be admitted. There may be no objection, but I think it's worth the time to emphasize that principle. Just because the declarant, who's just someone who makes a statement, is now on the witness stand, does not mean that all their prior statements are now admissible. All right. Now, because the evidence code applies, we know that we need to look for an exception if there's hearsay we seek to admit. And then again, I'm going to go a little quickly here because I know a lot of this is fundamental, elementary, if you will. But in family law, what we find, of course, is that what dad said, mom can generally use against him. And what mom said, dad can generally use against her. Those are statements by party opponents. The child, however, as I see it, is not an opponent to anyone. The child is in the middle of all this. So simply because the child made a statement doesn't necessarily mean that the statement can be used against the child, right? Keep that in mind. Statement by party opponent, as I see it, generally applies only to mom and dad. Again, I'm sorry for using only the heterosexual examples, the parents, all right, the opposing parents, if you will. And here, the only real limitation is that anything relevant the other side says can be used against it, subject to evidence code section 352. I could take some time to show you technologically, as I offered to do last year, if you have a deposition in a family law case, I repeat, if you have a deposition or some recording in a family law case, I'd love to see it. I'd love to see it. People are often on their best behavior in court, not always, but this may be the only time that I'm interacting with them or at least seeing them testify. I don't know a lot about them when they're outside of court, unless it's in a motion, unless it's in a mediator's report. What a person said on a prior occasion, I find enormously valuable. And I find it particularly valuable when I actually see the video, as opposed to someone just asking them from a transcript about what they did or didn't say on a prior occasion. With all the technology that's available today, it is not that hard to make excerpts of a recording, say from a deposition, of a statement that you think could be admissible at the trial. If it's of a third party, the prior statement could be admissible to impeach their testimony under 1235 of the Evidence Code and 770. If it's a statement of the other side, it's probably admissible so long as it's relevant. As long as it came out of the other side's mouth and it's relevant, you should be able to use it. Again, I don't believe that applies to the child. All right. Now, I'm going to skip through some of this, but I think procedure is worth spending some time on. Again, if you're asking someone about what they said at a deposition or in any sworn proceeding, do not paraphrase. I repeat, if you have a transcript, again, from a sworn proceeding as one example, don't paraphrase. Ask the question as follows. At the deposition, were you asked the following question and did you give the following answer? And I quote, who or what paid for the debt owed on the family residence? And did you answer? Throughout the marriage, I used my earnings to pay the monthly mortgage payments on the home where we lived. Were you asked that question and did you give that answer? Right? Sometimes in trials that I've watched or presided over, the attorney simply tells the witness, but you said this at the deposition, but never asks the witness, is that in fact true? Either A, did you actually say that? Or B, was the contents of that statement true? Just because you lodged the deposition, don't assume that the judge is going to be familiar with all portions of it, or is going to go back and read it. That's the best opportunity to confront that person with the prior statement, question and answer, whether under oath or not. Ask them whether they said it. Ask them whether it's true. So I think this is an important point in attacking and or supporting credibility of witnesses at trials. All right, I'm going to skip the slides that I had prepared. Bottom line, this is a deposition from, wow, it's been over 8 years now. And the exercise I was going to show is what if I wanted to splice it up and have a 5-minute segment of it. And you can see here that the deposition started at 11:43 in the morning, and using so many forms of software that are out there, you could simply drag and drop the deposition file into the editing software and simply go to the segment that you want to have ready for trial. Here at the, I'm going to pick the exactly 12 noon mark, and I split it there, split the clip. If I wanted a hypothetical 5-minute segment, then the next split that I make is I go 5 minutes later right to 12:05 exactly. I split the file there. I copy that little 5-minute segment. Right click, copy, open up a new file. New project, if you will, excuse me. Cut and paste that clip that I cut from it, and then I save it. And so, if this 5-minute segment had what was really important to me, testimony about when the house was purchased, when, if ever, community funds were used to pay down the mortgage, whether there are statements that might support watch charges, Epstein credits, so on and so forth, and I don't need the other 3 hours of the deposition, and I want to have it ready to go. I make this segment, I have it saved, I might have a corresponding transcript, and so when I go to play it, it's right set at the 12 noon mark, right? Hypothetically. Now, I'm going to go quickly through this, but again, I was asked for a discussion about hearsay, so I want to do that. We know the business records exception allows for hearsay statements that record an act, condition, or event, what I call an ACE, that was made in the regular course of a business, made at or near the time of the act, condition, or event, and by someone with personal knowledge of the ACE. I have that in brackets because it's not actually in the statute, the personal knowledge requirement. The feds have it, but I think the best approach is to have someone testify who has personal knowledge of those acts, conditions, or events. Not always possible, but certainly if you have someone with personal knowledge of the act, condition, or event, the hearsay is probably going to be found trustworthy. What you do need is a custodian or other qualified witness to testify as to the record's identity and mode of preparation. And again, the court must make a finding of trustworthiness. Wow, that's a lot. That's a lot to get in a business record. All right, a medical record is a business record. A phone record can be a business record, although there's often not a lot of hearsay in phone records because it's a computer that's generating the entries in a phone record. And if a computer's generating those entries, it's not hearsay. Dogs can't make hearsay statements, nor can cats, nor can a lot of computer-generated entries. Now, if a person is typing into a computer an out-of-court statement that's being offered for the truth of the matter, yes, that's hearsay, all right? But a phone record that shows when a call was made and to whom and for how long and where it originated from, that's not hearsay. It might require an evidentiary foundation, but it's not a hearsay issue. Now, if you subpoena the month of January 2021, you may need a declaration from the custodian of records that offers in the declaration for the truth of the matter that these are in fact the records on file with Verizon for the month of January 2021. That's a hearsay statement. But we know that under 1560, the evidence code, that declaration, which I just described, can be admissible for the truth of the matter, that these are in fact phone records from Verizon. And it would excuse the need to have the custodian testify at the trial or hearing. So again, when we talk about business records in family law cases, and not just in family law cases, we might be talking about bank records, although again, bank records are often computer generated. Those entries are generated by you swiping your debit card, and often it's not a human being making an out-of-court statement for the truth of the matter. Phone records, already talked about that. Medical records, now that is a document or a series of documents that often have hearsay statements. Maybe it's a nurse that talks about the time that the patient was admitted, his or her condition upon entry, whether they smelled of alcohol, that ETOH plus that you often see in medical records, what time a blood draw was done. But again, those are all acts, conditions, or events that the hospital has to record in the regular course of its business. And accounting records. Now, the records that your soon-to-be ex-spouse keeps of their side business, or maybe it's their only business. Can there be trustworthiness issues with those bank records business records? Of course there can. Of course there can, particularly if those records are being generated at a time when your soon-to-be ex-spouse knows that the records could be used in court and knows that the income and deductions are going to have a direct impact on the support they're going to pay, whether it's spousal or child support. So if you remember, I had on the slide for 1271, a big issue is trustworthiness. Are the records trustworthy? Even if it can be shown that they're made at or near the time of the act, condition, or event, that doesn't necessarily guarantee admission, okay? At the same time, I'm not saying that just because you have a sole proprietor business and it's just your law practice, for instance, and you do everything, you're your own paralegal, research attorney, secretary, process server, you get the point. I'm not saying that your records can't be admissible when you offer them. What I'm saying is that there's always this issue of trustworthiness built into the business records analysis. Now, it's very important that we not lose sight of the hearsay and often the double hearsay, double and triple hearsay that might be in a medical record, right? The patient says something to the nurse who says it to the physician, and the physician writes it into the record. All right? Because the hearsay, and however many levels that there may be, can raise issues under People versus Sanchez, particularly if we're having an expert testify in a family law case, and that expert is rendering his or her opinion based in part on what's in the medical records, or based in part on what's in the accounting records that may pertain to the valuation of the business, Pereira, Van Camp, those line of cases. Okay, so Sanchez and its progeny may rear its ugly head when an expert is testifying in a family law case and is rendering his or her opinion based on hearsay that has not yet been admitted for the truth of the matter. Okay, we're going to talk about that in a little bit. All right, Evidence Code Section 1523, Subdivision D, what I would call the voluminous records exception, the hearsay rule, although it's also found in the authentication provisions of the Evidence Code. Oral testimony, the content of a writing is not made admissible by Subdivision A of that statute, the so-called secondary evidence rule, if the writing consists of numerous accounts or other writings that cannot be examined in court without great loss of time, and the evidence sought for them is only the general result of the whole. So again, to the extent phone records are hearsay, often they're not because they're computer generated, but to the extent they are, could a witness who's reviewed all 1,000 pages of them testify under this section to the fact that there were numerous, perhaps hundreds of calls from the restrained person to the protected person? Yes, they could, in my humble opinion, under 1523 Subdivision D. The records should be available for inspection by the court and certainly by the jury if we talk about cases where there are juries, so not family law. But it is not a valid secondary evidence objection to say that a witness can't get up there and summarize the contents of voluminous records. Again, whether it's medical records, whether it's business records. All right. But when I think voluminous, I think more than just 100 pages. All right. I'm not going to cite you to a case that says there's a 500-page minimum. But we shouldn't need to have so-called experts testify about records unless they are truly voluminous, unless it's truly going to take up a whole lot of court time. Instead, the attorney should be ready to tell the judge to turn to page 17, line 8, or 91, section 5. You get the point. All right, I already talked about this a little bit, Evidence Code Section 1560, and how your records, your business records that you want admitted can be admitted without having the custodian come to court. Little different rules here for civil and criminal. Now, generally, when the subpoena is served upon the custodian of records, often it's accompanied by a blank declaration that the custodian fills out to show that the acts, conditions, or events described in the records were kept in the regular course of business, so on and so forth. And under Subdivision D of 1560, we are told that unless the parties otherwise agree, the sealed envelope or wrapper that contains the records shall remain sealed and shall only be opened at the time of trial or deposition or other hearing. Well, that kind of makes it difficult to prepare for those records if we haven't seen them before the hearing. Subdivision E says, as an alternative, the subpoenaing party in a civil action, family law is a civil case, don't forget it. Yes, you don't get a jury, but it is a civil case. The subpoenaing party may direct the witness to make the records available for inspection or copying by the party's attorney, the attorney's representative or deposition officer as described in the Code of Civil Procedure. When provided with at least 5 business days advance notice by the party's attorney, attorney's rep, or deposition officer, the witness shall designate a time period of not less than 6 continuous hours on a date certain for copying of records subject to the subpoena by the party's attorney, attorney's representative, or deposition officer. Is there anything that says a minor's counsel can't avail him or herself of Evidence Code Section 1560 and subpoenaing relevant records? Absolutely not. Minor's counsel can use these provisions every bit as much as the parents can. All right, subdivision F deals with criminal. We're not going to go through that. But before I leave subdivision E, I will state, quote, it shall be the responsibility of the attorney's rep to deliver any copy of the records as directed in the subpoena. Okay. Obviously, I shouldn't say obviously, but I would add that minor's counsel can also object to a subpoena that has been served that may compel the production, of records pertaining to their client. Whether or not the objection is meritorious is a different issue, but we often see objections to subpoenas that may be served to obtain records, private records of the parties in the action. Certainly minors have no less rights to object to subpoenas. Subpoena deuces take them, excuse me. Okay, moving on. So People v. Sanchez is going to have its 5-year anniversary in June. And I could go on and on about People versus Sanchez. Maybe there was no problem here that needed fixing, or maybe there was. I can go on and on about how half of Sanchez is pure dicta. There was no need to discuss the Constitution because the statutory analysis was a basis for reversal to begin with. That's an unfortunate tendency of courts these days. They love to talk about the Constitution when there's no need to, right? There's a doctrine of constitutional avoidance. We avoid discussing the Constitution unless absolutely necessary. It's still on the books, but often forgotten. But we need not talk about the Constitution anyway because that's for criminal. That's Sixth Amendment, right? Here we talk about the statutory analysis. A year ago, when I was trying to give this presentation before I ran out of time, I really thought to myself, Sanchez is going to one day make a sea change in family. Hasn't done it yet. Hasn't done it in civil either. A lot of the cases that I read last year in preparation for this presentation, not a whole lot has changed. The battle remains in criminal. The battle remains in sexually violent predator proceedings, kind of quasi-criminal proceedings in nature. We're not seeing family law cases involving Sanchez. We're not seeing a lot of civil cases involving Sanchez. They may say, well, Judge, that's because justice has kind of been on hold the last year during the pandemic, and perhaps that's true. Or perhaps it's the case that in family law, we rely on so much hearsay anyway that both sides lose if we take a very mechanical approach to experts considering hearsay statements. We kind of lose if the rule is going to be now that all children have to testify and be subject to cross-examination. I personally don't want that, and I doubt that any of you, certainly those of you that have children, want it either. So part of me is tempted to just say, don't worry about Sanchez, it's criminal stuff. But it's not. And what's more, tomorrow, the Court of Appeal could come down with a first case applying Sanchez in family law and cause a lot of changes. So I'll try and go through it as quickly as I can. But bottom line in Sanchez, and I'm going to take our eyes off the presentation for a moment. Bottom line in Sanchez was this: a gang expert, which is needed in a gang case in a criminal prosecution, got up on the witness stand and had to establish many, many things. That there was a group of 3 or more members that had a common name, sign, or symbol, whose primary activities included the commission of felonies listed in a particular statute, who had engaged in a pattern of criminal gang activity. So we're talking about prior crimes, the nature of those prior crimes, when they happened, who was involved, who had tattoos illustrative of the gang, who had what monikers in the gang. you can already tell it's almost impossible for one person to get up on the stand and testify to all of these things and prove it beyond a reasonable doubt. So often these gang experts are relying on the statements of others. Could be the statements of other peace officers that have documented the statements of other alleged gang members. Could be conversations that this expert has had with other alleged members of the gang. It could be a sea of hearsay. And so the courts understandably were concerned about this and basically reached the conclusion that if the expert is going to relate facts to the jury, that's the key word, relate facts to the jury, and rely on them for the truth of the matter to reach their opinion, there's a Sanchez problem. And what Sanchez says is these facts that the expert is relying on for the truth of the matter, in other words, the opinion is only as good as the truth of these facts, these independent facts must be proven and must comply with the hearsay rule. I'll repeat it one more time. Whether it's criminal, whether it's civil / family, if the expert is going to testify and relate certain case-specific facts to the trier of fact, family law, the judge, and his or her opinion relies on the truth of those facts to support the opinion or to provide a basis for the opinion, those case-specific facts that he or she relies upon must be proven. They must survive the hearsay rule. They must be relevant. Put another way, the expert is not a vehicle for all sorts of inadmissible evidence. It's certainly not a vehicle for inadmissible hearsay. So let's skip through these slides. Basically what these slides are saying is that the gang expert was extremely qualified, but he'd never spoken to the defendant, never lifted up his shirt and looked at his tattoos, never seen him in the so-called gang neighborhood or with other gang members. He had very little personal knowledge, if any, about the defendant and his gang, even though he was otherwise a very qualified expert. Mediators, on the other hand, mediators often have met with the parents, maybe met with the parents at the same time. And not in every case, but mediators may have actually met with the child or children. So it may only be one session, but it might be a lengthy one. And so mediators at least have personal knowledge of their interactions with the parents and the child. Okay, the holding. Again, case-specific facts must be independently proven at the trial or hearing in order for the expert to relate them to the jury as part of his or expert opinion. Now, if the expert doesn't state these facts as true, or for the truth of the matter, you might not have a Sanchez issue. No one is saying that an expert can't rely or can't consider on this hearsay evidence, all right? Again, whether it's something that the mediator said, whether it's something that a social worker said, whether it's something that the child said, one of the parties said. No one's saying the expert has to ignore all those things. It's just that the expert can't utter them on the stand and rely on them for the truth of the matter as such unless they're independently proven. Bottom line, what Sanchez reverses is the old, oh, it's not admitted for the truth of the matter, Judge. So the expert can say all these things, can be a vehicle for all these out-of-court statements because he's not or she's not relying on them for the truth of the matter. And you can understand we're in a case of the jury, hard to unring that bell. Now, there's no need to unring that bell if you subsequently prove those facts for the truth of the matter, but all too often that was not happening in criminal cases. All right, so case-specific facts that must be independently proven if the expert is going to relate them to the jury and rely on them. One, skid marks at the scene of a traffic collision. So the expert couldn't just get up and say, well, I believe that the defendant was, or plaintiff was driving at a speed of 85 miles an hour because the police report says, or the accident report says that the skid marks that were left were 100 yards in length, and goes on to explain the tires and the coefficient of friction. Well, there needs to be someone who's going to testify that the skid marks were 100 feet in length based on their own personal observation. If the only evidence of the length of the skid marks is the expert's testimony, not going to cut it. Hemorrhaging in the eyes noted at autopsy. All right. This can, but not always, be circumstantial fact supporting strangulation. Well, it's nice, it's advisable to have a police officer who may have seen that at the autopsy, or the actual pathologist who saw that at the autopsy, or perhaps a treating physician who inspected the decedent before the decedent passed to the coroner's office. Now, that doesn't mean that an expert who didn't examine the decedent will have no possible way of relating this hearsay and relying on it. Why? Because if the hemorrhaging is included in a business record, a medical record, for instance, and if those medical records are properly admitted, say by virtue of Evidence Code Section 1560, and under 1271 of the Evidence Code, there's a hearsay exception for what's in the medical records, then the expert, even though he may have never even seen or touched the decedent in person, he or she may talk about the hemorrhaging because that hemorrhaging has been independently proven elsewhere in the proceeding. A unique tattoo on a defendant's associate, I'll skip through that, and get to the fact that a personal injury plaintiff suffered a serious head injury as a child. All right, and I can see this coming up in cases where there's been an allegation of neglect or abuse in family law. And so if the expert says, in my opinion, and this could be an opinion based pertaining to custody, visitation, etc. My opinion is based on a portion of the mediator's report, or a police report for that matter, or a CPS report, wherein the child alleges that father smacked her in the head several times. Okay, that fact, that father smacked the child in the head several times, is going to have to be independently proven. The expert's testimony about it cannot be admitted for the truth of the matter. The expert very well may have read the reports and may rely on those reports and form an opinion as to what the child custody and visitation schedules could be or should be. But if the expert's opinion is based largely on a hearsay statement of someone about abuse or neglect, and that hearsay is not admitted through an exception to the hearsay rule, or that abuse is not independently proved, this opinion should probably be stricken. At least that's how Sanchez would apply in a family law case. All right, general background information is still okay. So what we're told is that in a street gang prosecution, the expert can still talk about the general history of the gang. For instance, how the Mexican mafia formed many decades ago. That's fine. An expert could testify about what we normally see when there's been abuse of a child or neglect of a child. That's fine. That's general background information. An expert could talk about studies that he or she has reviewed about what are best forms of parenting for children of certain ages, children with certain needs. That's fine. When it comes to case-specific facts, the expert cannot relate those to the trier of fact and or rely on them unless they're independently proven in compliance with the evidence code. All right, so again, this is a slide I had last year. Does Sanchez apply to family law? And the answer, I believe, is yes, but we don't have any cases interpreting it yet. And again, I think the reason is because Sanchez is not terribly practical in child custody and visitation matters, right? We don't want to have children testifying in every single case and being cross-examined in every single case. And I like to think that our mediators do a very good job, including in those cases where the children are interviewed. And let's face it, as the finder of fact in a family law case, I don't normally find that I need to hear testimony from the child. And the last thing I think I would ever do, I'll eat my words one day, but the last thing I think I would ever do would be to ask the child, he or she's under oath, yeah, which parent would you rather live with? I would never do that. I don't need to. Questioning of the child about what he or she likes to do, or what he or she likes to do or does when he's with mom during the week or with dad on the weekends, whatever the arrangement can be, just listening to the child talk about these experiences, whether the child's face lights up or whether the child is hesitant to discuss it, often tells me all I need to know about what the primary residence of the child should be. I don't need to ask questions like, who do you want to live with, and then watch the child be cross-examined about how wonderful mother is or how terrible father is, or vice versa. And again, I think even when parents truly, truly hate each other, despise each other, ordinarily, though not always, ordinarily, they're trying to keep children outside of the courthouse, much less the courtroom, much less the witness stand. But where I think there could be issues, and I sort of discussed this with the Sanchez slide, is if the basis, whether it's a restraining order or whether it's for a change in custody or custody order in the first instance, is alleged abuse or neglect, and the only way to prove that is from hearing from the child, I think Sanchez rears its head. Now, the child may have made a spontaneous declaration, where we don't have excited utterances in California. We have a similar concept, a spontaneous declaration. The child made a spontaneous declaration to mom. If the elements are met, 1240 of the evidence code, perhaps that spontaneous declaration is admissible without the child testifying. A lot of criminal cases say, and it's not just limited to criminal, just because the child may be incompetent to testify in court doesn't mean that the child's hearsay statements are inadmissible. Let me repeat that. Just because the child may be found incompetent to testify in court doesn't mean that the child's hearsay statements are per se inadmissible. So spontaneous declaration is just one example of where a child's hearsay statement may be admitted, and then there wouldn't be a Sanchez problem. Okay. Again, we know that Sanchez has been applied to proceedings under the Sexually Violent Predator Act. Conservatorship proceedings, okay, that's going to come up in probate, right? It's probably going to be based on hearsay statements of family members, perhaps guardians, perhaps hearsay statements of the conservatee, okay? A lot of these things are going to have to be proved for the truth of the matter for the expert to relate and rely upon them before the fact finder. Again, I'm not going to spend too much more time on Sanchez because it's just not taking hold in family law cases yet, if ever. It's not taking hold in civil cases yet, if ever. That does not mean it doesn't apply, but I don't have really any more information about its applicability to family law than I did this time last year. So I can skip through a lot of these slides. Where I prepared these slides was to talk about the mediation process, what we call CCRC here in Riverside County, and how there's a lot of hearsay that the mediator may be considering and preparing his or her report. And of course, the mediator can be called at the RFO or trial, and the mediator can be cross-examined. And so the question you may have is, the mediator subject to Sanchez? I think the safe answer is yes. But again, if you want to protect yourself, perhaps you need to use the SDT process that we talked about earlier to present the school records, right? To present the medical records, the CPS records, if you can access them, so that you have an evidentiary foundation for the opinion that the mediator may be giving, or as I have another slide, the child custody evaluator, or an expert under 730 retained by the party. Again, the bad news here is you may have to really dot your I's and cross your T's and issue more subpoenas than you previously would. Or if you have a good working relationship with the other side, this can all be done by stipulation. But I think if you take nothing else from this, anytime you're going to offer expert testimony in a family law case, and anytime that expert testimony is going to be based potentially on case-specific facts, abuse, neglect, things of that nature, you better be ready to independently present it. You better be ready to independently present it. The expert is not going to be the vehicle for otherwise inadmissible evidence. The expert is not going to be a vehicle to admit hearsay that otherwise can't be proved. And, you know, as bench officers, we are presumed to be able to separate hearsay from non-hearsay. We're supposed to not be influenced by inadmissible evidence that we may hear. We sustain and strike objections even though we've just heard it. Still, that does not mean that you can simply have an expert testify to all sorts of wide-ranging things and say, Judge, this isn't admitted for the truth of the matter. Don't take that approach anymore. You're going to be creating new case law under Sanchez. Okay, I know I'm going very fast. Talk about stipulations. Again, subdivision C of 3111. The child custody evaluation report may be received on stipulation of all the interested parties and is competent evidence as to all matters contained in the report. Again, stipulations get us around Sanchez. I'm going to go very quickly through this because give me one moment, folks. All right, what are some examples of case-specific hearsay that could come up that an expert in a family law case may want to testify about, relate to the finder of fact, and rely on these facts for the truth of the matter? A real estate appraisal database. What could this include? How about Zillow? Zillow. If the question is the valuation of the house now, time of trial, for instance, there could be issues where there was appreciation in the value of the property before the marriage. So one party purchased the house before the marriage, shortly thereafter got married. And so that party might be entitled to some of the appreciation in the house, if any, before marriage began and before community earnings were used to pay down the mortgage, right? Zillow's just one. We could argue back and forth about whether it's reliable or how reliable it is, but does it include case-specific facts? So if Zillow is getting the data on houses on your street or your client's street or nearby streets or nearby neighborhoods and using those sale prices, whether historical or currently pending sale prices, to value your property, is that case-specific or is that general background information? Personally, I think it leans more towards general background information. At the same time, I see a good argument for case-specific facts because it could be relying on current prices right now as reflected in the MLS, the multiple listing service, right? And of course, what else? The price that's listed for a home could be based on the whims of the owner, the seller. They may be trying to get too much money out of it. They may be desperate and have dropped the prices. These are all things to consider in calling an expert if you have a trial or a hearing on trying to determine how to distribute the community and separate property interests in a home. Maybe you need to call a local real estate agent who's familiar with the properties on that street or streets. I already talked about our business records for your soon-to-be ex-spouse's business, perhaps a sole proprietorship. Are they admissible pursuant to the hearsay rule? And the answer is yes, they can be. You could use it against the other side if they're in his or her own handwriting. That's statement by party opponent. But even if not, they could be admissible under 1271 as a business record, again, if they're trustworthy. And the trustworthiness is going to depend often on when the record was made. Was it made before divorce, dissolution was contemplated or known? Was it made during? Or was there some motive to fabricate what's in the records? All right. But again, to just call an expert to testify about your soon-to-be ex-spouse's earning capacity or present earnings or deductions and not provide the evidentiary foundation of the actual records, it's risky. It's risky. It can create hearsay issues, and not just hearsay issues, Sanchez issues. Again, what's Sanchez? It's a general prohibition on experts testifying before the finder of fact and relating to the finder of fact case-specific facts as if true, in other words, for the truth of the matter, and then relying upon them. Police reports, double, triple hearsay. CPS reports, same thing. Let me repeat. Am I saying that these are documents and or databases that an expert cannot rely upon? No. Of course, any competent expert is going to consider these things, is going to allow them to affect his or her opinion. They'd be incompetent not to look at these records. What I'm saying, or what the Supreme Court is saying in Sanchez, is that for the expert to recite the contents of these documents and or databases and or records, to recite them for the truth of the matter and reach an opinion based on those recitations, that implicates Sanchez. And I went a little bit on my diatribe about dictum in courts being all too eager to talk about the Constitution when it's not necessary. I will tell you, in a recent case, and it's a criminal case, but we don't know when Sanchez is going to rear its head in family. Someday it's coming. But in a criminal case, not too long ago, one that was tried in 2007, but the Supreme Court rendered its decision last year. It's a capital case that often takes a long time. The witness was a pathologist, and the issue was fetal viability. It used to be, years back, that if a pregnant woman was murdered, it was only, quote unquote, a double murder if the fetus was viable at the time and the fetus passed away. The law has since changed. The fetus does not have to be viable for it to be a double murder if you murder the pregnant woman. But at the time of this trial, that was still a requirement, viability. And an expert testified who did not conduct the autopsy of the pregnant decedent woman or the fetus. But this expert reviewed the autopsy report of the pathologist who did. And the expert ultimately rendered an opinion as to the viability of the fetus, therefore supporting the conviction at the time. There was no objection in 2007. If there was an objection to this testimony, the Supreme Court didn't write about it. Nevertheless, it appears that the Supreme Court, on its own motion, although aided by a reply brief that raised for the first time the Sanchez issue, the first time, in fact found Sanchez error by the pathologist testifying to the contents of another pathologist's report for the truth of the matter to ultimately reach her opinion as to viability of the fetus. That kind of concerns me, not because I think it's an improper application of Sanchez, but if there was no objection, why is it coming up 10, 12 years later? Yes, criminal is a little bit different, but what I'm trying to tell you is even though Sanchez hasn't reared its head in family law, someday it's going to. Someday it's going to in civil. Which one happens first? I don't know. I found a reference to Sanchez, an unpublished opinion of a high-value couple, and the wife had sought to have an expert testify about a database that was prepared with respect to the husband's expenses, husband's income. It was a marriage that didn't really have any community property, but the husband had large sums of separate property, having sold his interest in Hotmail to, I don't remember if it was Microsoft or Yahoo, but he made a ton of money from the sale. He was paying $100,000 a month in child support and spousal support. And so obviously his current income, his current assets and future earning power was going to be relevant. The Sanchez objection was raised and rejected, not really considered. The case is unpublished. That's the closest that I found to a court talking about the applicability of Sanchez in a family law case. Circa 2018, 2019, I think Representative Morlock, I think he's actually a state senator from Orange County, introduced a bill to exempt civil and family law cases from Sanchez. The bill died in committee. It never got voted on. That's kind of where we stand. All right. Again, experts and their opinions may rely on inadmissible hearsay, but they may not relate the inadmissible hearsay to the jury. Let me slow down and repeat that. Experts and their expert opinions may rely on inadmissible hearsay, and inadmissible hearsay can be very helpful to an expert's opinion, but that expert may not relate the inadmissible hearsay to the jury for the truth of the matter. So the rule from Sanchez is rely on it, don't relate it. Okay. Back to children specifically, and again, children as witnesses, and then we're going to conclude here. So in preparation for today, I did my best to remind myself of how the law draws a line for children in various areas. What am I talking about? Age 14 is a big deal in criminal law. If the child is under the age of 14 and the perpetrator touches the child with the requisite lewd intent under Section 288 of the Penal Code, that is a felony. It's a violent felony. It's a registrable felony. There does not need to be actual touching of privates to be guilty of Section 288. The law kind of draws the line at that age 14. If you touch a child under the age of 14 beyond a reasonable doubt with the requisite sexual or lewd intent, that is a very serious and violent felony under California law. That's the line the legislature has drawn. There's no defense of, I thought she was 17. I thought she was 18. I thought she was 15. It doesn't matter. There can be reasonable mistake of fact defenses for children over 14, but not for those children under 14. For children that are under 14 that are suspected of crimes, there is a case called Gladys R. And what police generally must do or should do is inquire of the young person about their understanding of right or wrong, their understanding of whether it's against the law or not against the law to steal, or whatever the crime may be. It's important to ask the child who taught them that, whether it was mom and dad. It's important to ask the child to give an example of what would be stealing or what would be hurting someone else and why that's a good or a bad thing. There needs to basically be, under Penal Code Section 26, evidence, not beyond a reasonable doubt, but evidence that the child has an understanding, a clear understanding of the wrongfulness of his or her conduct in order for that child to be subject to prosecution. Not long ago, the legislature amended 602 of the Welfare and Institutions Code to say that children under 12 cannot be prosecuted. Children under 12 cannot be prosecuted anymore unless for a very small list of crimes, murder being one of them. So the legislature, in various ways, in various areas of the law, draws various lines for children. If you want to subpoena a child as a witness in a criminal case, for instance, if the child is 12 or over, you must subpoena both the parent and the child in order to properly compel the child's attendance at court. So we're talking about first that line between 14 and up, 12 and up, okay? Now, in CalCrim 330, and I'm sure that there is a counterpart in Casey, CalCrim are criminal jury instructions, Casey are civil jury instructions. We talk about the testimony of a child 10 years of age or younger. And the instruction states, quote, "You have heard testimony from a child who is age 10 or younger. As with any other witness, you must decide whether the child gave truthful and accurate testimony. And of course, in evaluating the child's testimony, you should consider all the factors surrounding it, including age and level of cognitive development. When you evaluate the child's cognitive development, consider the child's ability to perceive, understand, remember, and communicate. While a child and an adult witness may behave differently, that difference does not mean that one is any more or less believable than the other. You should not discount or distrust the testimony of a witness just because he or she is a child." Now, I have, of course, up on the screen pictures of children testifying, and although there are times when that may need to occur, I think most of us would all agree that the goal is to keep the children out of the courthouse, much less the courtroom, and certainly the witness stand. But to what degree do the children have voices in family law cases? And again, can these voices be amplified by minors counsel? The answer is yes. Minors counsel can be an excellent thing. Before I go any further, I want to thank those attorneys that are either currently on our list or seeking to be on our list. Thank you so much. But while, of course, you all could read from the CE book yourselves, I think this section is very, very well written, better than I could ever put it. And so I want to read it to you now. This is section 7.27. If a child is of sufficient age and capacity to form an intelligent preference regarding custody, the court must consider and give due weight to the child's wishes in making determinations regarding custody. This puts a duty upon me as a judge, Family Code 3042. But of course, a child's participation in family law matters must be considered on a case-by-case basis. When a child wishes to participate, the court should find a balance between protecting the child, the statutory duty to consider the wishes of an input of the child, and the probative value of the child's input while ensuring all parties' due process rights to challenge evidence relied on by the court in making custody decisions. Rule of Court 5.250. Okay? Kind of a reminder of Elkins that we kind of started this lengthy segment with. The child's age alone is not determinative of whether the child's wishes must be considered and weighed. I'll repeat that. The child's age alone is not determinative of whether the child's wishes must be considered and weighed. Rather, such qualities as the child's sincerity, bearing, and degree of maturity should be judged. Ladies and gentlemen watching this, I think this is excellent language. I think, however, that a minor's counsel can establish these facts to the court much better than trying to expect the child to do it on his or her own. All right, in a case called Marriage of Rosson, R-O-S-S-O-N, 178 Calap 3rd, 1094, the wishes of children 10 and 13 years old, whom the mediator found to be, quote unquote, very mature, were properly considered and given some weight. On the other hand, Marriage of Melmauer, M-E-H-L-M-A-U-E-R, 60 Calap 3rd, 104, the trial court did not err in finding that the wishes of a child 14 years old were not supported by mature reasoning. It all goes back to what this passage began with, case-by-case analysis. A child's wishes are entitled to greater consideration in modification proceedings than in the initial custody determination, because in the former situation, the child will have lived with the arrangement and will have a more informed basis for his or her preference. Now, as many of you know, if a child is 14 years old or older, that same dividing line we have with PC 288, if a child is 14 years or older and desires to address the court regarding visitation or custody, a court must receive that testimony unless it determines that it would not be in the best interest of the child. I'll repeat that. If a child is 14 years old or older and desires to address the court regarding visitation or custody, a court must receive that testimony, keyword, unless it determines that it would not be in the best interest of the child, in which case the court must state its reasons for that finding on the record. But again, I find the mediators often make it that I don't need to hear the testimony. The child has a right to be heard, but heard doesn't necessarily mean testimony. I'm not saying I would never hear the testimony of a child, but again, if the parties are properly cooperating in mediation, if I have a thought out and well-written mediation report, often I don't need the child in the courtroom. And right now, of course, we want fewer people in the court as is with coronavirus. Now, a minor's counsel, an evaluator, an investigator, or a recommending mediator must inform the court if he or she has information indicating that a child in a custody or visitation matter wishes to address the court. But again, to me, the distinction is it the child that wants to address the court, or is it the parent that wants the child to address the court? A very important distinction to me. The former, yes, the child has a right, again, particularly a 14 or older, to address the court. But if it's the parent who wants the child to address the court, that I'm going to be suspicious of. A party or a party's attorney also, and I would insert here minor's counsel, may advise the court that the child wishes to address the court, and the court may itself inquire if the child wishes to do so. I can do it on my own request, even if nobody else brings it up. Now, what about under 14? A court also may allow a child under the age of 14 to address the court or provide other input about custody and visitation if that is in the child's best interest. When in doubt, insert best interest. The factors that the court should consider when determining whether addressing the court is in a child's best interest may be found in Rule of Court 5.250. Don't you think this is made more simple for the court when there's minor's counsel? You bet. Family Code 3042 does not require a child to express to the court a preference or to provide other input regarding custody or visitation. And it doesn't require it. Now, a court must control the examination of a child witness to protect the child's best interest. Evidence Code Section 765B concerns the examination of a witness under age 14. Looks like I forgot to research one statute in preparation for today. Let's just see what 765B says. We're almost done, folks. Thank you for your patience. Love it. Ran out of power. Well, let's see if it's one of these books. How about that? 2021 Evidence Code. Getting warmer. All right, subdivision B. Remember, we don't have subsections in California, we have subdivision. 765 subdivision B. With a witness under the age of 14, the court shall take special care to protect him or her from undue harassment or embarrassment and to restrict the unnecessary repetition of questions. The court shall also take special care to ensure that questions are stated in a form which is appropriate to the age or cognitive level of the witness. The court may, in the interest of justice, on objection by a party, forbid the asking of a question which is in a form not reasonably likely to be understood by a person of that age. Who better to raise that objection than minors counsel? All right, almost done. If the court precludes calling a child witness, it must provide an alternate means of obtaining input from the child and other information regarding the child's preferences. Again, who better than minors counsel? All right. Ladies and gentlemen, I want to thank you for giving me this opportunity to present this. I learned a lot from it. There's always more to learn. I have been reminded of how important minors counsel is. And minors counsel is important because children are important. And that's such a critical part of the family code and the family law court. I hope I've reminded you of how you have many rights as minors counsel and, of course, many responsibilities. I hope I've educated you a little bit more on trends in evidence law right now. Again, Sanchez will rear its head at some point. We're not sure when. In the meantime, do everything you can to make admissible and be prepared to admit in evidence any case-specific facts that your expert will rely upon. Let's, if I may, let's all encourage ourselves, try to keep children, particularly younger children, out of the courthouse, out of the courtroom, and off the witness stand. But if that day comes when a child will have to testify, we as bench officers will be considering whether minors counsel is appropriate. Hopefully minors counsel will be available. And let's do our best to have all available information ready so that we can make the best decisions that we can as to custody and visitation. In my opinion, they're almost never easy decisions. Again, they're almost never easy decisions. So I think it's really good to know that even if a child is not technically a party, a child can be treated with all the same rights and responsibilities as a party, including having counsel. Folks, thank you so much. Thanks for everything you do. Thanks for lasting through this never-ending pandemic. We will get through it. We'll get through it better than before. Thank you.